Shai, for such a warm and kind introduction. Before I begin my presentation this morning, I must tell you that Honorable Chief Justice of India was looking forward to this event. In fact, both of us had a very detailed conversation about this event. And he was to travel to Hyderabad and after the NALSA event yesterday and then join us from Hyderabad. But he was not able to go to Hyderabad because soon after the event at NALSA got over, he was feeling unwell. And then in the evening, when I was in touch with him, he was not able to speak because he had got such a bad throat. And he was down with a viral, probably a viral turn of the weather problem. So Chief Justice of India has asked me to convey to you, all of you, his sincere regrets that he couldn't join in. And since all of you have assembled, I thought we should anyway continue with the event so that we take this mission forward. A very good morning to all the Chief Justices of the various High Courts. Thank you very much for joining in on a Sunday morning. To the Director of the National Judicial Academy, Justice A.P. Shai, who has been a very distinguished colleague of mine, both at Allahabad and in Lucknow. To the members of the E-Committee, Justice Sawan, our Vice Chairperson, and the other members of the E-Committee, and all the other persons from NJA, the resource persons, and everyone else who has joined in this event. I have the privilege today of doing the curtain raiser and addressing all of you on a topic which is important not only to me personally as the chairperson of the E-Committee, but for the Indian judiciary as a whole. And the purpose of having all the Chief Justices here for this specialized event, we could have done this as a part of the Chief Justices Conference. But the reason why we are having a Chief Justices Conference only on ICT is because of the immense potential and importance of this subject to the Indian judiciary. As I speak to you, we are conscious of the fact that there is a great digital divide in India. And the purpose of the e-courts project is not just to foster the adoption of technology. This is not just a committee on technology, but it's a committee on technology which is going to be used with a socially purposive object in mind. And we cannot lose sight of the fact that all the work which we do in the context of technology is intended to benefit those for whom our services are intended ultimately to reach out. And absent this vision of the connect between technology and the lives of citizens for whom we exist, I think the purpose of the E-Committee would be lost. So I begin with that we are just not a committee on technology, on artificial intelligence, but we are a committee on technology with a socially purposive object, which we have to foster. Last year, when the COVID-19 pandemic affected India and many other countries across the globe, our lives changed in many ways. We can all remember the urgency with which all services and institutions in India shut down, including our own courts. Chief Justice Bobde was in saddle, and the first thing which he asked me when the lockdown came was, how are we going to run the courts? And we had no clue about what we are going to do because this was unprecedented. But we decided to develop our own video conferencing platform and then to try and adapt sooner than later. Until that moment, none of us could have imagined a situation so devastating that the courts and the judiciary of the nation would also succumb to its effects. However, such a situation in fact did arise, and we all saw our work being affected. Not only that, the lives of all those directly concerned with litigation before us were also affected. Lawyers, litigants, court staff, and judges have been profoundly affected by the pandemic. I think all of us have either suffered from COVID. We are fortunate to be here that, despite suffering from COVID, we are still here. But we are also conscious of the deep impact it has made in terms of friends we have lost in the judiciary, among lawyers, in civil society. Our own families have been affected by COVID. So this is something where I think the Indian judiciary stands together with the rest of the nation. Our judiciary, the Indian judiciary, adapted to the evolving situation at a rapid pace. Only a few months into the pandemic, the Supreme Court and the High Courts were reopening for litigants, albeit with one major change. All our proceedings were now going to be conducted virtually. To many individuals, including the advocates, the litigants, our court staff, and for many of us, this was a situation we could not have imagined. Soon, many of us found ourselves making decisions which were not exactly judicial decisions, but would directly affect our justice delivery mechanism. Decisions such as the choice of platform for virtual courts, how those would operate, how access to them would be controlled, amongst others. I quite remember that almost every day I would be engaging with judges across the country, or with many chief justices and their judges. Simple questions: could we use Zoom? Has the Ministry of Home Affairs clamped down on Zoom as possibly a security hazard? Which are the other platforms we can utilize? What about the district judiciary, where the requirement, the footprint is so much larger? Can we afford those services of different platforms? So these were all doubts which were really prevailing in our mind. It all took us time, but I do believe that the courts settled into the system, and it is also being implemented even in the district courts and now quasi-judicial tribunals. Some of the high courts have even gone a step further and started live streaming their proceedings for everyone in the country to watch. At this stage, let me tell you one thing, that part of the mission of the e-courts project is to give ownership of this project to the high courts. So over the last 1.5 years, when we utilized the fairly low level of judicial activity to tap the services of our high court judges across the country, I had formed several committees chaired by chairpersons of the computer committees. The Chief Justices cooperated by nominating those judges in responding to my request. And the idea of constituting these committees was to allow high courts to give an input, because high court judges and high court chief justices are really deeply aware of local circumstances. So instead of this becoming a top-down project, this would really become a project which would develop from the district courts and then go upwards to the Supreme Court, and we would only facilitate the project. So in the context of live streaming, for instance, the committee framed live streaming rules. We had some amazing suggestions from various high courts, including judges. I remember Chief Justice Akhil Qureshi devoted a great deal of time and gave us some valuable inputs on where we were perhaps going wrong, and we were able to adopt those inputs and bring them back into the fold. So at the outset, I must tell you that this has been your project. Justice Rajiv Sagdar is there, Justice Nitin Zamdar, Justice Satish Sharma, who is going to be shortly taking over as Chief Justice, Justice Sivagnanam, Justice Arvind Kumar, who's going to be taking over as Chief Justice very shortly. So all of these judges, I'm sorry if I've missed anybody in the first committee, but these judges really constituted the live streaming rules under the guidance of Justice R.C. Sawan. Today, almost 18 months since the pandemic began in India, it is quite common for any observer of the Indian judiciary to compare the implementation of ICT, or Information and Communications Technology, in the Indian judiciary to the introduction of virtual hearings. Indeed, these observers cannot be faulted, because that change of the physical to the virtual hearings is the most obvious one and which is visible for everyone to see. However, to those of us inside the Indian judiciary and working to implement ICT within it, the story cannot be further from the truth. Virtual hearings during the pandemic may be the visible interface for the judiciary with technology in the eyes of the observer, but the real work goes on behind the scenes. It is for this continuing mission that we assemble as we analyze the present and look to the future. Just a few moments ago, Justice Shahi mentioned that the E-Committee of the Supreme Court has come a long way since it was first constituted by Chief Justice Lahoti in 2005 to prepare a national policy and action plan for implementing ICT across all courts in India. On 1st August 2005, the E-Committee came up with its first action plan, in which it divided the work into 3 phases. The first phase began almost immediately and involved the setting up of basic ICT infrastructure in our courts. I will not burden you with all the data and the statistics which I normally present when we are speaking to the outside audience, because we don't have to glorify ourselves, we know the data. The first phase, therefore, immediately began. Thereafter, on the 8th of January 2014, the E-Committee proposed an action plan for the second phase, which had to ensure that all the ICT infrastructure so set up was well coordinated. Finally, the current E-Committee has released the draft proposal of our action plan for the third and the final phase, which hopes to make digital natives of the entire Indian judiciary. Now, one radical change which we brought about when we were when we were proposing and drafting the vision plan for the third phase, as distinct from the earlier phases, was that the entire vision document earlier was prepared within the E-Committee in Delhi in the Supreme Court. I thought we must not really maintain a monopoly over the vision document, because this is an office which we hold in trust for society. So I constituted a very broad-based committee consisting of experts who are drawn from civil society. That was one facet. Constituted a committee of our own judges who will engage with those experts, because ultimately we have to produce and give those inputs to the experts. And the experts then have prepared a vision plan and document, which we have circulated to the high courts and for which we have received some amazing suggestions from all of you, and which are being incorporated as part of the phase 3 document. For those of you who are newspaper bots, as the saying goes now, you would have read a lot of some articles written on our phase 3 vision document, including in the Indian Express. There are people who have expressed some apprehensions that are we going too far with networking and digitization? And will this mean that the average Indian citizen will now be completely within this framework of an electronic umbrella? So these criticisms also I take with a very positive sense, because they only remind us that we need to also preserve essential aspects of privacy. So for instance, as we will be going along, I'll present to you that some very vital elements of privacy, of data security are involved in the work which we put forth on the online platforms. One of our missions has been to implement APIs or application programming interfaces, as a result of which all the data that we have can be tracked immediately, to begin with, by government departments, who are the largest litigants in our court. Now, this process which we have inculcated of having a transparent functioning of the E-Committee is good in a sense, but it has limitations, because much of the data that we purvey on the NJDG, as I will shortly point out, is data concerning the lives of citizens, data concerning matrimonial cases, data concerning family disputes, data concerning commercial disputes, data which pertains to child sexual abuse. So we have, of course, our own parameters for blanking the data, but equally there are concerns about data security and privacy. And another committee, again of experts coordinating with judges, is presently engaging in this aspect of how going forward we maintain concerns of data privacy and security, on which I will of course be relying on all the Chief Justices and the judges of the Computer Committee to give us their inputs. Let us therefore take a moment to acknowledge all the work which has been done. The current state of the ICT framework in the Indian judiciary is not a knee-jerk reaction to a global pandemic, but is part of a process which has now been going on for almost 16 years. The pandemic accelerated the push towards going digital. Doing so was possible only because we had been working for many years before that to put in place the necessary infrastructure. And therefore, we must necessarily recognize the contribution of those who have preceded us, Justice Madan Lokur, Justice Bharuka, who headed the committee right at the outset. These were people who initiated the process, and we are taking on the mantle from them. This is not to suggest that there have not been any challenges. Rather, this sudden push has shown that there were often glaring gaps in our ICT implementation, both at the micro and at the macro level. At the micro level, the most obvious gap was the one closest to home. Many of ourselves, we were not fully well versed with technology and may not have been too keen to adopt it in favor of our tried and tested judicial traditions of many years. We have colleagues who tell us that ab to itne saal bache hain, why do I have to change my ways of doing the way I have always learned to do my work? So I think the primary barrier is not so much the digital divide, but it's the mental divide. Judges ourselves not willing to adopt ICT as an instrument of our working in our day-to-day lives. Every day when I sit in the Supreme Court, whoever has been sitting with me, I constantly persuade my colleagues, please do go online, please be completely in the electronic files. And speaking for myself, all my files are delivered to me electronically. My notes I type on OneNote, which is a platform which is available to me. And therefore, my judgments are all given to me in the electronic form. The daily orders are given to me at the end of the day to edit on the electronic form. I can share with you, brothers and sisters, that the consequence has been that I think I've, over the last 1.5 years, I've almost lost the touch of really writing in my hand. If I have to write a document in hand, it becomes difficult because I have learned to type so fast. I'm like all of you because I'm in fact an older generation than all of you. After all, does not the idiom go that you cannot teach an old dog new tricks resonate to all of us? I remember personally the amount of difficulty that I faced when I first had to read a 1,000-page file on my laptop, correct daily orders with track changes on, since my secretaries could not visit the office or figure out how to unmute myself in a virtual hearing. Undoubtedly, there was a steep learning curve for me personally. However, with time, I think I became used to it and now have embraced it with some vigor. Personally, I cannot imagine making my notes in hand while reading a file. Doing so digitally allows me to save notes more safely and in a far more convenient manner. When conducting virtual hearings from home, I often use multiple screens at once. I have one screen to attend the proceedings, one to read the file, my laptop, and one to speak to my colleagues on the bench on the other side. So when, for instance, when we were all working from home and my colleagues were all in their home offices, we would have one screen where we would have Google Meet on the whole day. So we would mute the lawyers for the moment, tell them that we want to now discuss your argument, discuss the three of us, even if we were sitting in a bench of three, discuss on Google Meet, and then tell the lawyers what the conclusion of our view was. So this has been a remarkable change for all of us. Similarly, this difficulty was also faced by our court staff and members of the bar. However, slowly, they too adopted and are now reaping the benefits. Many counsel appearing before my court often tell me that they now cannot imagine arguing a matter without relying on their iPad, and that we should expect this to become a regular occurrence even when physical hearings resume. Hence, it is not the case that this transition was difficult per se for anyone, only that we needed the right push, some help, and had to persevere to doing it every day to make it a habit. As we all know, especially the young lawyers look up to the judges. They look at the judges as mentors, as role models. Just yesterday, we lost Justice D.R. Dhanuka, very distinguished judge of the Bombay High Court, whose son is a colleague, valued colleague and judge of the Bombay High Court. And Justice Dhanuka was a great mentor to us, and we would all look up to him and try and emulate him, his academic ways of doing his work. So the young lawyers are constantly looking up at the judges. So when they see a judge working on their own laptop, trying to go electronic, that's exactly what the young lawyers are going to do. Young lawyers, I find this across the country now, are addressing the Supreme Court on the virtual platform. I believe that we became truly a national court because of the pandemic. I would say because of the pandemic, because it compelled us to go virtual. We have lawyers from across the country, be it from Maharashtra, from Kerala. I've had lawyers from Tamil Nadu, from Hyderabad, from Andhra and Telangana, of course, from Bihar, you just from Gujarat, from West Bengal. We've had lawyers across the country arguing cases before us. So this has really catapulted the Supreme Court into a truly national court for the first time. The problems at the macro level, however, were of a slightly different nature. Often these were problems in relation to the issue of access itself. Since many advocates and litigants could not be expected to have ready access to facilities which would allow them to appear before us virtually or do e-filing on their matters. However, I do firmly believe that the Indian judiciary rose up to the challenge, and we all share credit for that. All our courts set up proper facilities which could be used by the public to access virtual hearings. Similarly, help was provided to those who could not virtually file on their own by providing facilities which were placed across various court complexes. The E-Committee has also been working along with courts and judicial academies and the Department of Justice across the country to provide adequate training to advocates and court staff on how to access these benefits and make use of them. Understandably, this is not something which can happen in a day or a month, because it is not only teaching something entirely new to many of these individuals, but also is about encouraging them to adhere to it even in the future. To do so, it is also incumbent on the Indian judiciary to ensure that access to such facilities continues to be provided by us so that no one is prevented from accessing our justice delivery mechanism because they do not own a laptop or do not have access to proper internet facilities. Now, one of our initiatives, which was to set up e-Seva Kendras across the country so that every court complex should have an e-Seva Kendra, the purpose of doing this is as to ensure that lawyers and litigants do not have to suffer for want of internet access or want of access to all the facilities which ICT provides, so that the courts must provide them. And part of our mission is to go down to the Gram Panchayat level, as I will shortly present, and then provide access to our citizens. At the same time, our experience with this transition to the ICT in the Indian judiciary also brought to light the pitfalls and the plights of many individuals with disabilities, whose voices have often been silenced. When we proceeded to make everything digitally accessible, it turned out to be the case that our accessible was not really accessible to many such individuals. In the name of e-filing, for instance, many advocates would just file scanned copies of printed documents, which would then not be read by individuals with a visual disability. Similarly, many of the websites of our courts, including the Supreme Court website and the High Court websites, were exceedingly difficult for them to navigate. Hence, taking note of the feedback that we received, we ensured that e-filing happens in a way that is more accessible. Further, the E-Committee has worked with all the high courts to ensure that their websites are disabled friendly and accessible to everyone. I requested Ashish Shiradhonkar, who's going to make a presentation soon after me this morning from NIC, who is the backbone of this project, to engage with some of the blind lawyers across India. 3 young lawyers, Ashish has joined, 3 young lawyers engaged with Ashish so that he could make changes in the design of the CIS software to make it accessible to the visually disabled. The E-Committee has worked with all the high courts to ensure that their websites are disabled friendly and accessible to everyone. Therefore, what this did was to make us question our preset notions about what accessible truly means to those of us with privilege and what we need to do to ensure that information is truly accessible to everyone. And all high court websites now are accessible. Having spoken at length about our experience in the past 18 months in virtual hearings and e-filings, I think it is also crucial for me to acknowledge the other innovations that have been made in the ICT sphere of the Indian judiciary. The foremost of this is the National Judicial Data Grid, or the NJDG. The NJDG is a game changer because it truly revolutionizes our understanding of the realities of the Indian judiciary. It has become a household complaint across our country that the courts are overburdened and judicial delays are rampant. Hence, discussions are often had about how we can reduce these delays without truly questioning their nature. However, for the first time, we can now elevate the quality of this discussion by basing it upon real-time statistics. The NJDG provides statistics in real time about the number of cases pending across the Indian judiciary, be it the high courts or district courts. And part of the reason, actually the main reason why we have brought this galaxy of Chief Justices to the table today, is to indicate to you how you can use the NJDG as a court management tool in fostering the efficient management of the high courts and the district judiciary. Therefore, it will help all high courts to effectively monitor the performance of subordinate courts and their judges, often by just looking at concrete numbers. Although the NJDG still has one crucial weakness, if I can call it a weakness at all, and that is that the NJDG is useful only if appropriate data is entered into it by all the courts. Now, one of the problems which we have encountered is high courts not uploading the data into the NJDG accurately. Hence, it becomes the duty of every high court to ensure that they themselves and all the courts in the district judiciary under their jurisdiction are entering the relevant data regularly to make NJDG useful for everyone. The committee has also made strides by creating a novel mobile application which can be downloaded by all the members of the bar in order to access the e-services expeditiously. It also aims to be the bar's one-stop solution to managing their workload digitally by truly making all services to the court feel digital. Similarly, all the high courts have also been running numerous e-initiatives of their own in order to further the ICT implementation in the Indian judiciary. Some of the examples of these initiatives are those which have been used to make the courts more digital, such as the introduction of the virtual courts for traffic challans in Delhi, which is now spread to other parts of the country, the introduction of paperless courts, and video conferencing facilities between courts and jails. Others include those which have been introduced to provide ease of access to the bar and the litigants, such as the setting up of dedicated e-seva cameras, providing Wi-Fi, ensuring e-payments, and communication by the registry through emails and SMSs. The Supreme Court of India, in a new initiative, has ensured that certified copies of the orders shall be delivered to the doorsteps of litigants by engaging with the Department of Posts, in an initiative which I would commend to all high courts to adopt as well. Further initiatives have also been aimed at increasing transparency, such as putting up justice clocks, digitization of court records, to which I will come in a moment now, providing e-statistics, and starting live streaming of all court proceedings. So these are some of the unique initiatives which have been adopted across the country and which I believe are now a key to the future. Let me, in the latter part of my presentation this morning, go straight to the digitization initiative, because this is a very crucial part of the reason why we are here. We had constituted a committee on Digital Preservation Standard Operating Procedure, the SOP, and associated with it, the e-filing adoption. The committee consisted of some of the best experts from the private sector and from the Government of India and its agencies. The committee has worked almost for the last 8 or 9 months. It has engaged with the High Court ICT committees, and we now have in place an SOP for digitization. Digitization of court records is a central focal point of the e-courts initiatives. It should enable judicial administrative processes to move forward to becoming more environmentally sustainable by minimizing paper-based filings, physical movement of documents from one forum to another, and travel of lawyers, litigants, and other actors to reduce the carbon footprint of the courts. We anticipate that 3,100 crore documents will be digitized in the next 5 years, and that will include all old and current records. The Digital Preservation Standard Operating Procedure for the Indian judiciary has been evolved on the basis of international standards and best practices, considering the enormous volume of digital records being produced by the courts. One of the reasons for the SOP was that a large number of high courts, Delhi is there, one of them, Allahabad is one of them, Madhya Pradesh is there, Karnataka, Tamil Nadu, different high courts were doing digitization at their own level. Now the concern is this: we must ensure that the work of the high courts is interoperable, so that ultimately access is available not just within that state, but even for the Supreme Court and for other high courts across the nation. Second, we must ensure that technological obsolescence does not destroy what we are doing today to digitize. For instance, all of you would recall the floppy drives, which we used to use, or we used those cassettes when we used to listen to music. They were replaced by CDs. Now that's absolutely what was par for the course is completely now obsolescent. So how do we ensure that this digitization work which we are doing today does not become obsolescent? Second, how do we ensure today we are confronted with 3,100 crore page documents, 3,100 pages of documents, crore pages of documents. How do we ensure that this digitization work does not have to be done in future? Now, unless we combine digitization with e-filing, what we are doing today will have to be done 5 years later or 10 years later down the line. So we have to avoid that. Digital preservation encompasses scanning, digitization, preservation, storage, search, and retrieval. The SOP provides for preservation of e-records and mechanisms to make this record accessible, reliable, discoverable, authentic, and usable for a subsequent reference. The standardization of all aspects of digital preservation across high courts and district courts will help in achieving greater interoperability between data repositories and benefit the Indian judiciary in accelerating the overall justice delivery system. The digital SOP plans to establish dedicated judicial digital repositories to manage and preserve the digital records of the high courts as well as the district courts under their administrative control. The SOP includes a detailed data protection strategy along with step-by-step implementation guidelines. The SOP focuses on several objectives, among them, first, digital preservation of judicial records to cover digitized as well as born digital, that is computer-generated electronic records. Two, to address the looming challenges and threats of rampant technological obsolescence. Three, envisage an interoperable implementation model and trustworthy mechanism for digital preservation for boosting efficiency, consistency, and exchange of trustworthy records, data between judicial entities. Four, judicial digital repositories could be leveraged for building artificial intelligence and machine learning based intelligent application for efficient and accurate justice delivery system. The SOP provides a comprehensive digital preservation budget estimate of rupees 2,677 crores, covering the requirements of 25 high courts and 673 district courts, spreading across 5 years. In my engaging conversations with the Chief Justices, when we were preparing the SOP, one of the problems which was expressed was, what about budget? All state governments are not necessarily on board with the Chief Justices to provide the kind of budget. And I'm engaging with the Government of India to ensure that a budget is provided as a part of phase 3 to ensure that digitization can take place in a robust manner. The overall cost includes the cost of digitization, metadata creation, curation, establishment and management of a cloud infrastructure by the high courts, JDR management, audit and certification, development, deployment and technical support for digital preservation tools and software solutions at about 0.886 rupees, that is 86 paise per page. Suggestions were called on the SOP from the High Courts. On considering the suggestions, SOP version 1.0 has been approved by the Committee for Implementation. A flagship project will be implemented in collaboration with High Courts on priority so as to establish the model infrastructure, systems, and best practices that can be developed and replicated across remaining High Courts in the District Judiciary. Let me go on now to e-filing. It cannot be understated that digitization of court records must be accompanied by e-filing. In phase 2 of the e-courts project, the e-committee introduced systems for digitization for the digital. However, the prevalent form of filing in most cases continues to be in the physical form. If this continues in a few years, we may again be staring at a huge case record which is in need of digitization. This may frustrate the very object of the digitization project. Thus, along with digitization, there is an urgent need for adoption of e-filing by all the stakeholders of the judicial system. Now, we have the e-filing module, which Ashish will tell you about, e-filing module 3.0. Why is there this resistance among lawyers and our stakeholders to adopt e-filing? The High Courts need to engage with the advocates and bar associations to sensitize and encourage them to adopt e-filing proactively. But it is high time now for us to institutionalize e-filing in the judicial system. To begin with, and this is my suggestion to all the learned Chief Justices, to begin, e-filing can be made mandatory for all government institutions in all matters. Secondly, in revenue, tax, arbitration, and commercial disputes, e-filing should be made mandatory. In the case of the district judiciary, suits for the recovery of money, loan recovery suits by banks, arrears of rent, complaints under Section 138 of the NI Act, applications for maintenance, petitions for divorce by mutual consent, and bail applications can also be considered for mandatory e-filing. You may also think of making e-filing of petitions, appeals, and revisions against judgments and orders of the district courts mandatory. In such a case, the required record of the trial court can be digitally linked with the appellate or the revisional court. This will serve as an incentive for litigants and advocates to adopt e-filing, as they will not need to be required to file copies of the trial court record in the petition, appeal, or revision. Embrace of technology by judges is equally important to institutionalize digitization. I may share that I access, as I told you, all court cases on a digital platform. It has come to the notice of the E-Committee that advocates are insisted upon to submit physical copies of the case, even if they have resorted to e-filing. This defeats the very entire purpose of e-filing. We had this problem in the Supreme Court as well, and the Secretary General of the Supreme Court devised a solution for this. If we are going to ask the advocates to file e-file copies and to also print out the same copies and submit them in the filing section, then why would an advocate give you an e-filed document? Then they'd rather give you what they were doing always in the past. Advocates are reluctant to file cases electronically since in any event they have to submit the physical copy. In this regard, I request Chief Justice to engage and issue appropriate practice notes or circulars to withdraw the requirement of submission of physical copies of the case files if e-filing has been made. So some of the inputs I've already prepared in the form of a draft letter, which I'm going to address to the learned Chief Justices, and I'm going to share with you. Finally, in the last part of my presentation, I want to engage with all of you on the National Judicial Data Grid, because this is a court administration and court management tool which now is available at your fingertips. And I would encourage you to start using this, because then all your colleagues, including the colleagues in the administrative committees, will start using this. NJDG, as you know, provides for monitoring of the pendency and disposal on various parameters. Data from all the high courts and all district courts is available on the NJDG. As on date, data of more than 4 crore pending cases from the district judiciary and 56 lakh cases of the high courts is available on the NJDG. The real-time statistics of NJDG. Now, you would ask me, all this information is fine, but how does it benefit what I have to do in my work as a Chief Justice? Now, the real-time statistics on NJDG can be used in multifarious ways by Chief Justices and administrative judges. First, as a court management tool, 2, as a case management tool, 3, for policy planning, 4, for policy decision making, and 5, for digital inspection of the trial courts. One can generate reports age-wise, stage-wise, type-wise, orders which are not uploaded list, undated cases list of every district, taluka, and high court. For example, I'll just give you an example for this. You can have a list as Chief Justice of a particular case type, which is say 20 or 30 or 40 years old from all the district courts in your jurisdiction. You can start with the oldest and then come to the more recent. 2, list of cases pending in district courts which are stayed by the High Court or by the Supreme Court. 3, list of appeals pending with percentage of more than 5-year-old appeals and which court has the greatest number of these appeals. Administrative judges can use the admin login. There is something called the admin login on the NJDG for a variety of administrative purposes. This login for admin can be created by the Central Project Coordinator, the CPC of the High Courts, for the Chief Justice, for the portfolio judges of High Courts, for the principal district judges, for the Chief Judicial Magistrates, and other administrative registrars according to the requirements of each High Courts. The admin login has several tab options in the NJDG, like a dashboard, administration, national masters, news section, data monitoring, management tools, server monitoring, NJDG reports, DCMS, ePay, virtual ePay, Open API, defunct, help desk, and the CSC. Similarly, several important submenus are available, including Query Builder. I'll come to it in a moment. Return report, judge-wise disposal, establishment-wise reports, police station-wise pendency, case type-wise, so on and so forth. So this will really provide not only for the administrative judges, but also we can use it in engaging with the superintendents of police to ensure that we have a tab on the police station-wise pendency as well. These reports are on a real-time statistics that can be put to use to improvise the efficiency of various courts. Another very important court management tool available for an admin user is the dashboard option, where an administrative judge can log into the dashboard of any particular court under their judicial district. So you can conduct the entire inspection of your district in a digital format. Under the admin login through the dashboard, the administrative judge can check the disposal for a particular month by a particular judge. Under this option, the entire list of cases disposed of by the judge will be displayed for that particular month. The administrative judge can check the time spent by the court in disposing of the case and can also directly view the orders and judgments of a particular judge. This is a game changer for the Indian judiciary, which will pave the way for increased judicial efficiency and productivity. We all know, I've been an administrative judge. I was an administrative judge in Nashik, in Kolhapur, various parts, then Mumbai later on. We know the amount of time that we used to spend when we used to travel to the districts for the physical inspection of the district judiciary. All that can be done today on the NJDG itself. So you save the burden of having to visit the districts. You can engage with the districts, and this is a continuous 365, 24/7 monitoring with the administrative judges can do. This menu is available only for the admin users under the tab Management Tools, through which the administrative judge can log in directly to the CIS dashboard of any particular district or taluka court. Through this login, the administrative judge can get the total pending cases of that particular court, the disposal of that particular court for a given month, top pending cases category-wise of that court. The admin user can also view the cases under mediation and Lok Adalat of that particular court. Hence, this menu provides for digital inspection of any court under the district judiciary by the administrative judges of the High Court, the principal district judge, or any administrative head. This is a tool which is a way forward in attaining complete digital inspection without physically visiting the concerned court. Next important feature, under the District Court Monitoring System, DCMS report, an administrative judge can effectively monitor the district judiciary's work on any particular day. The Chief Justice can also monitor the work which has been done on a particular day. The report captures cases fixed for evidence, witnesses examined, issues framed, charges framed, arguments heard, part heard matters heard, disposal of interlocutory applications, disposal of contested and uncontested cases, cases filed civil or criminal of any particular court. Next important feature, under the Information Management tab, a variety of options for data maintenance is available, like data monitoring summary, court judge report, and under trial report. Now, under trial report is crucial because you can imagine everybody is talking about under trials. We have the entire data of under trials available at the flick of a button for us if you are only willing to access it as Chief Justice and administrative judges. The summary report available under data monitoring is a very comprehensive report on various aspects of courts under the heads state-wise, total districts, total court complexes, total establishments, total cases, total orders, and orders not uploaded. The NJDG showcases another important report, which is regarding the under trial prisoners. The under trial report can be obtained for the entire state with district-wise breakup of figures. There is also another option through which the number of under trial prisoners in a particular district can also be viewed. Under the admin login, the pendency of cases of any district or establishment of a particular court can be generated under this option. This will be useful for an administrative judge to understand what is the workload of cases of a particular district or an establishment or a particular court, and even decide whether there is any need for bifurcation of courts or not. Through the tool Dispose Case and Order, the entire history and lifespan of a case can be digitally inspected by an administrative judge. As stated earlier, the administrative judge can get the entire details of the disposed of cases, including case details, case status, case history, along with final orders and judgments. We have a query builder option. The query builder option available under the admin login is the most useful court and case management tool. Using the query builder, one can generate a variety of customized reports according to one's individual needs. The query builder has a variety of options for generating reports from the NJDG data. You can get a report of pending or disposed of cases with multiple search criteria and combinations such as case type, stage-wise, act-wise, party-wise, as per registration date, filing date of any particular state or district. In other words, the query builder is really, it's been described very aptly as the Akshay Patram of NJDG and has the potential to generate numerous combination reports needed for effective court and case management. So really, my purpose in troubling all of you to come here this morning is to really encourage all of you to make this initiative on digitization and on the NJDG a success. We have all the data available at our fingertips. The problem today is not the absence of data. The problem today is how do we use now this data in a scientific manner for fostering the ICT engagement of the Indian judiciary. And as I began by saying, ICT is not in that sense an elitist, newfangled tool which has been developed for the Indian judiciary. Yes, some of the instruments which we have used are cutting edge. They compare with the best in the world. But the object of doing this is to reach out to those for whom our services are intended. You'll be surprised, and I'll conclude with that example. I had a case last week. An accused who was involved in the Howrah Delhi Rajdhani blast in 1993 was absconding till 2010. In 2010, he was arrested in Lucknow. He applied for bail before us, saying that after a lapse of nearly 11 years, even charges have not been framed. Am I not entitled to bail as a matter of course? So we asked for a report from the special judge saying what were the reasons why even charges have not been framed. So the judge came to us with a very candid report. He said for 5 years, the accused had asked for a legal aid lawyer. The District Legal Services Authority did not provide a lawyer to him for 5 years. So for 5 years, we were waiting for a lawyer to be appointed by the DSLSA. Thereafter, for 2 years, the government did not appoint a public prosecutor. So we were waiting for 2 years for a public prosecutor. For some period, there was an appeal pending in the Supreme Court of the co-accused. Therefore, all the papers had gone to the Supreme Court. And finally, he said, one of the co-accused is lodged in the Ghaziabad jail, while this accused has to be tried at Ajmer. And therefore, for want of production of the co-accused, the trial cannot go on. Another case, almost every day in the Supreme Court, we come across cases where people come to you after 17 years or 19 years of actual imprisonment in a 302 conviction. And initially, we used to pass orders that, well, this will not preclude, even if you are dismissing the appeal, that this will not preclude them from applying now for remission of a premature release. But what is the guarantee that this will be actually implemented? So these are heartrending stories, which we as judges, I'm sure you hear many more of these stories across your day-to-day work. And the purpose of really bringing all of the best minds in the judiciary to this platform today is to ensure that we have this data now available at our command, on which there has been such a substantial investment by the government of India. The Secretary of Department of Justice has been extremely forthcoming, Mr. Barun Mitra. When I requested him that, well, we need to have very substantial funds, almost 2,700 crores for digitization, he has in fact been guiding the E-Committee as to how to present a proper document so that it can be ultimately accepted on the financial side. So we'll be pursuing those initiatives. I'm conscious of the fact that there are limitations on the state governments for funding the state judiciaries. We will take that up at our level. But at least the data which is available for all of you, please do use that data. Encourage e-filing by engaging with the members of the bar. Give them incentives. And we must reduce the disincentives, which I have mentioned, namely of compelling people to file both in the paper and the digital format. And we can certainly tap the government as the largest litigant to start e-filing, at least by a particular cutoff date. Because the government cannot have an answer to us that they will not commence e-filing. We certainly cannot burden to start with, people who do not have the funds or the money, but we can certainly insist that the government can start e-filing. So with this, I would like to end. I had a lot more to say, but I've already taken almost 50 minutes. Ashish is here, who is really the master of the role, if I may say. And he had an internet problem at his residence, rushed from his residence in Pune to his office, got his office opened on Sunday so that he could make this presentation to this very august gathering of Chief Justices. I thank you very much for coming and joining me and for your time. And I'll now give the podium to Ashish to make the presentation. This will be the nitty-gritties, really. Thank you.